The Honourable the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honourable Senators, I have granted leave of absence to Senator Dr. Lester Henry, Senator Avinash Singh, and Senator David Small, all of whom are out of the country, and to Senator H.R. Ian Roach, who is ill. Honourable Senators, I have received the following correspondence from Her Excellency the President Paula May Weeks. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Gavin Simonet. Whereas Senator Dr. Lester Henry is incapable of performing his duties as a senator by reason of absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Acting Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Gavin Simonet, to be temporarily a member of the Senate with effect from the 29th of May 2018 and continuing during the absence out of the country of Senator Dr. Lester Henry. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's, this 28th day of May 2018. To Ms. Ayana Lieber Lewis. Whereas Senator Avinash Singh is incapable of performing his duties as a senator by reason of absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Acting Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ayana Lieber Lewis, to be temporarily a member of the Senate with effect from the 29th of May 2018 and continuing during the absence out of the country of Senator Avinash Singh. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's, this 28th day of May 2018. To Mr. Ronald Duke. Whereas Senator David Small is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ronald Duke, to be temporarily a member of the Senate with effect from the 29th of May 2018 and continuing during the absence from Trinidad and Tobago of the said Senator David Small. given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, this 28th day of May 2018. To Pastor Clive Dottin. Whereas Senator Ian Roach is incapable of performing his duties as a senator by reason of illness, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Pastor Clive Dottin, to be temporarily a member of the Senate with effect from the 29th of May 2018 and continuing during the absence of Senator Ian Roach by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the office of the President St. Anne's, this 28th day of May 2018. Honorable Senators are required to take the oath.
I, Garvin Simonet, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Ayana Lewis, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Ronald Duke, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Clive Dottin, having been appointed a member of Parliament, to affirm by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Petitions, papers. Announcements by the President.
Honourable Senators, I have received the following correspondence from the Deputy Speaker of the House of Representatives. May the 28th, 2018, Senator the Honourable Christine Kangaloo, President of the Senate. Dear President of the Senate, establishment of Joint Select Committees. On Friday, May the 25th, 2018, the House of Representatives agreed to the following resolutions. 1. Resolved that in accordance with Standing Order 64-1C, the Trinidad and Tobago Revenue Authority Bill 2018 be referred to a Joint Select Committee to be established for its consideration and report. 2. Resolved that in accordance with Standing Order 64-1C, the Income Tax Amendment Bill 2018 and the Mutual Administrative Assistance in Tax Matters Bill 2018 be referred to a Joint Select Committee to be established for its consideration and report. Subsequently, on Monday, May the 28th, 2018, the House of Representatives agreed to the following resolutions. 3. Resolved that in accordance with Standing Order 64-1C, the Tax Information Exchange Agreements Bill 2018 be referred to the Joint Select Committee established for the consideration and report on the Income Tax Amendment Bill 2018 and the Mutual Administrative Assistance in Tax Matters Bill 2018. 4. Resolved that subject to the concurrence of the Senate, the following 6 members be appointed to serve with an equal number from the Senate on the Joint Select Committee established to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018. Mr. Colm Imbert, MP, Mr. Faris Al-Rawi, MP, Mr. Terence Dialsing, MP, Mr. Adrian Leons, MP, Mr. Barry Padarath, MP, Mr. Rudranath Indar Singh, MP, and that the committee be mandated to report by July the 31st, 2018. 5. Resolved that subject to the concurrence of the Senate, the following 6 members be appointed to serve with an equal number from the Senate on the Joint Select Committee established to consider and report on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and the Tax Information Exchange Agreement Bill 2018. Mr. Colm Imbert, MP, Mr. Faris Al-Rawi, MP, Ms. Marlene McDonald, MP, Dr. Lovell Francis, MP, Mr. Fazal Karim, MP, Mr. Rodney Charles, MP, and that the committee be mandated to report by June the 30th, 2018. I respectfully request that these matters be brought to the attention of the Senate for its concurrence, please. Respectfully, Mr. Esmond Ford, MP, Deputy Speaker.
Petitions, papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honour to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The annual report of the Central Bank of Trinidad and Tobago for the year ended September 30, 2017, the consolidated audited financial statements of the Petroleum Company of Trinidad and Tobago Limited for the year ended September 30, 2017, and the annual audited financial statements of Trinidad Nitrogen Company Limited for the year ended September 31st, 2017. Thank you, Madam President.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Education. Owing to the late payments of salaries to principals of private secondary schools, which are affecting close to 90% of these schools, what steps are being taken to resolve this issue?
Minister of Education.
Thank you very much, Madam President. For fiscal year 2018, the Ministry of Education has remitted funds to the private secondary schools for fees for students placed at these schools for terms 1 and 2. On the 21st of May 2018, the Ministry received claims for term 3 payments of fees for students at 5 schools, namely Bishop's Centenary College, Corpus Christi College, Christ College Vocational Trade School, Open Bible High School, and elders classes. And on the 29th of May 2018, an additional claim was received from Johnson's Finishing School, totaling 6 out of 13 schools. The ministry is at present processing payments for term 3 to private secondary schools for students placed by the Ministry of Education at their establishments. Thank you.
Senator Mark.
Yes, thank you, Madam President. Madam President, through you, can the Minister indicate what mechanisms or measures would he be taking on behalf of the government to avoid this situation recurring in the future, particularly in reference to the statement that he has made about 6 out of 13 schools not being able to receive their third term fees?
Minister of Education.
Madam President, it is quite clear to me that Senator Mark was not listening attentively when I was speaking. I never said that there are 6 schools who are unable to receive their claims. What I stated was that 6 schools have sent claims to the Ministry of Education. And therefore, I would suggest that Senator Mark would listen more attentively whenever I answer any question. Thank you.
Senator Mark.
Yes, I'm listening more attentively now. Can I ask the Honourable Minister when he intends to settle these claims from those schools as it relates to outstanding fees?
Minister.
Thank you very much, Madam President. In my response, I stated clearly that 6 schools have submitted claims. It depends on the schools when they submit their claims, and it's only when they submit their claims then we can effect payments. So as soon as the remaining schools submit their claims, we are going to treat with those claims and pay these schools as soon as possible. Thank you.
Next question, Senator Mark.
Thank you, Madam President. To the Honourable Minister of Energy and Energy Industries. In light of reports of the presence of a thick crude oil near the 3 sisters of the Columbus Bay, has the source of the oil leak been determined? And what steps, if any, are being taken to address the problem?
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, Petrotrin reported to the Ministry of Energy and Energy Industries that an oil spill of approximately 2 to 3 barrels occurred in the Soldado North field on Friday, the 25th of May, 2018. The origin of the spill is currently believed to be the well Soldado 694, which was being abandoned by rig number 50. That's the spill that occurred a couple of weeks ago. The trajectory analysis of this spill showed that the oil would move in a northwesterly direction. Vessel and aerial surveys conducted verify this. No other oil spill was reported or observed since the 25th of May 2018 in the Soldado field to the Ministry of Energy and Energy Industries. This spill, however, was small and was contained and cleaned up. Petrotrin responded to the report of an oil spill that was apparently sighted near the rocks known as the 3 Sisters of Columbus Bay on Sunday, the 27th of May 2018. However, Petrotrin reported that no oil was observed by them in that area upon conducting a site visit. As such, no further response was deemed necessary. An aerial survey was conducted by the Ministry of Energy and Energy Industry and the Trinidad and Tobago Air Guard yesterday, Monday the 28th of May 2018. The carcass area was included in the survey. No oil was observed by the surveillance team.
President, having regard to the frequency of oil spills and oil leaks, particularly by Petrotrin, can the minister advise this Senate what steps are being taken by Petrotrin to address this recurring problem, particularly on our coastlines?
Minister.
Madam President, as is common knowledge throughout Trinidad and Tobago, and as I've been on the record as saying on numerous occasions, one of Petrotrin's bigger risk items is its asset integrity. We are aware of that. We are concerned about that. And very often, as the Prime Minister rightfully said, when he goes to sleep at night, he's scared about that. We are using our best efforts in terms of surveillance, and we are, through risk analysis, attempting to replace the assets that are most at risk in terms of oil spills. But it's a major challenge, and we continue to monitor the Gulf of Paria very, very closely.
Senator Mark.
Madam President, could the Honourable Minister indicate to this House what specific steps can you share with this House that the government have taken or will be taken to address this matter? Because you have indicated that this is a nightmare. And therefore, could you share with us what specific steps have been taken or are being contemplated by the government to address this entire issue? Madam President.
Minister.
Madam President, as I have said, we're using risk analysis to determine what are the assets that are at greatest risk. We are monitoring it very closely. We are shutting off systems where the pipelines, for example, are under severe stress and the integrity is in serious question. So, as a matter of fact, that is one of the main reasons that Petrotrin's oil production has been dipping slightly. It is because of safety concerns. While it is not the ultimate solution will cost billions of dollars, but we are monitoring it very closely. And I knock on wood that nothing more significant has been happening over the last year.
Questions on notice, questions for oral answer.
Leader of Government Business.
Madam President, the government is pleased to announce that we will be answering questions number 111 and question 134. We ask for a deferral of questions 135 and 136.
Questions number 135 and 136 are deferred for 2 weeks, for 14 days. Senator Hussain.
Madam President, question number 111 to the Prime Minister.
Minister of Agriculture, Land and Fisheries.
Madam President, I thank Senator Hussain for this question and for his patience in awaiting the very brief response. In relation to the date on which the MOU was signed, the MOU was signed by the Government of Trinidad and Tobago on 10th October 2017. And in relation to the parties who signed the Memorandum of Understanding, that's implicit in the question, the parties are the Government of Trinidad and Tobago and Sandals Resorts International. I thank you.
Senator Hussain.
Madam President, can the Minister indicate whether or not any MOU, any concessions or tax breaks are being given to Sandals Resort International?
Senator Hussain, I won't allow that. That question does not arise. The question, if you look at it, is very specific. Senator Mark.
Can I ask the Honourable Senator and Minister whether the Memorandum of Understanding that has been signed whether the government would be prepared to table it in the Parliament for public viewing?
Minister.
Madam President, I would not be able to answer that. I am not familiar with the contents, and it's a question that Senator Mark may be able to pose at a later date.
Senator Hussain.
Then can the minister indicate, based on the memorandum of understanding being signed on the 10th of October 2017, when is the projected date on which this project is taken to actually start?
Senator Hussain, I won't allow that question either. Next question, Senator Mark.
Thank you, Madam President. Question 121 to the Prime Minister. Seeing that I'm hearing, yes, may I invoke?
Not at this stage. You remember there's a time at which you can invoke.
Okay.
All right?
Yes.
So
I am so guided.
yes, so
Let me go to question number 134 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, the Ministry regards the incident as extremely serious, and in this regard, 2 separate investigations into the matter were commissioned. NIDCO commissioned one independent investigation, and the other was commissioned by the Maritime Service Division. The report of both investigations was submitted, and their conclusions are not at variance. Basically, the report concluded that the primary cause of the fire was due to poor workmanship in the installation of the lagging around the exhaust silencers over one of the replaced engines. The supplier and installer of the lagging was done by R&R Industry Supplies Limited through a competitive tendering process. Madam President, based on the findings of this investigation, I have directed NIDCO to immediately refer the matter to the Attorney General Office for consideration and action, and the private legal counsel to consider NIDCO's recourse against the company responsible for installation. I thank you.
Senator Mark.
Yeah, Madam President, can the Minister indicate, having regard to the challenges faced by this particular water taxi, whether the government is considering removing that particular vessel completely from the route, that is, traveling or traversing between Scarborough and Port of Spain, and confining it to its original destination, San Fernando to Port of Spain.
Minister.
Madam President, these vessels were designed for the waters between Trinidad and Tobago. Again, the cause of the fire was poor installation on the lagging of the exhaust silencer. And once that is rectified and certified by the class certification, we see no reason to withdraw the vessel from the Trinidad to Tobago or the Port of Spain to San Fernando facility. Thank you.
Madam President, through you, can the Minister report on the state of that vessel since the replacement of the part that he has mentioned? Has the vessel performed adequately to the satisfaction of both NITCO and the Maritime Services Division?
Minister.
Thank you. Madam President, since the incident, the vessel has not been put back into service because we would appreciate once there's a fire on a vessel, certain class certification has to take place, and there are some repairs that would have arisen because of the fire in terms of the cables and the cable racks that were destroyed. So since then, the vessel has not been back in service. It will only be back in service once it is certified by the class certification. Thank you.
Senator Mark, before Senator Rambharat wishes. That's all right.
Thank you, Madam President. Through you to the Minister, I would like to know, these are not new vessels, so I would like to ask, you have spoken about designed. These vessels are designed for the route between Trinidad and Tobago. Now, is it maintained for the routes between Trinidad and Tobago?
Minister.
Madam President, I have said on numerous occasions that we do have a problem with proper maintenance in Trinidad and Tobago, and the water taxis are no exception. And that is why the government, through NITCO, has gone out for maintenance, technical maintenance service contract, and the purpose of that is to put all government vessels under a proper maintenance contract, because we do have challenges. These vessels are fairly new. These vessels came in 2010. So now vessels are not considered old if they're just 7 years in the making. So I would admit that we do have challenges with the maintenance, and this is being addressed as we speak.
Madam President, through you to the Honourable Minister, in light of the critical importance of this water taxi for citizens traveling between San Fernando to Port of Spain and back on a daily basis, can you provide this House with any degree of assurance as it relates to when this particular vessel would be back in service?
Thank you, Madam President. Madam President, in 2010, 4 water taxis were purchased. As we speak, 3 of these vessels have been down since the fire. What we decided to do is to check the lagging on the other vessels. So by next week, we would have 2 of the vessels up, which will satisfy the needs from the San Fernando to Port of Spain route. And once the Trini Flash, which was involved in the fire, have been class certified and the repairs completed, then we will have the 3rd vessel back on. And sometime later on this year, NITCO is expected to have the 4th vessel back in service. But 2 vessels do satisfy the needs on a daily basis.
Yeah, Honourable Minister, can you share with this Honourable Senate how long these vessels were withdrawn from service to undergo precautionary repair measures, as you have indicated? How long this has happened?
Minister.
Thank you. Madam President, since the incident, NITCO has undergone a complete check of the 3 vessels that were in use, and that is the reason why 2 were taken off, and we expect by next week 1 to come back on, because what they did is that they had the class inspect the other vessels to make sure that what happened with the Trini Flash does not reoccur with the other vessels. They were very proactive to use that incident to recheck the lagging on the other 3 vessels. So these 2 vessels would have only come off just the day after the incident.
Senator Rambharat.
Thank you, Madam President. To the Minister, Since there's insufficient maintenance right now by the ministry to handle these vessels, and I understand you are putting things in place for that, now this poses a greater risk to persons who are using.
Senator Rambharat asked the question, please.
The question is, what now exists, what, other than the matters with the lagging, what risk mechanisms have been identified that can pose a risk to the members who are using the Cobostar vessel at this time, or whichever vessel, the Cabo Star?
Madam President, I think the Honorable Senator might have been a little mixed up with the vessels. The Cabo Star is a cargo vessel. What we are speaking here is about the water taxis. The water taxis are completely different. The maintenance is handled completely different. The Cabo Star is a vessel that we leased, and the owners of the Cabo Star, they are responsible for the maintenance. The water taxis are maintained by NITCO, and I did not say that there's no maintenance. What I said that we are not satisfied with the level of maintenance, and there have been no established risk outside what have happened with the Trini Flash at this point in time.
Senator Mark.
Yeah, Madam President, I'd like to invoke Standing Order 27, sub 15, as it relates to question number 121. And Madam President, as I'm on my legs, may I inquire through you what is happening with question number 13, as well as question number 78 for written answers, Madam President.
Senator Mark, you may be aware that the standing order was invoked for question number 13. If you wish to invoke the standing order for question number 78, you can do so.
Madam President, I'd like to invoke the appropriate standing order as it relates to question number 78.
Honourable Senators, Standing Order 2715 will be invoked for question number 121, and Standing Order 2716 will be invoked for question number 78.
Motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business. I understand that you want to ask that
I understand that.
Okay. Honourable Senators, it is my understanding that the members are desirous of having this particular business matter be deferred to later in the proceedings. So, Honourable Senators, we will defer and return to item number 40 later in the proceedings.
Public business, government business, motions.
Attorney General.
Thank you, President. Thank my colleagues for that warm but slightly delayed response as well. I think it is standing in the back of this chamber. Madam President, I beg to move the following motion standing in my name. Whereas it is provided by Section 34(1) of the Administration of Justice, Deoxyribonucleic acid, Act 2012, hereinafter referred to as the Act, that the Minister may make regulations for the purpose of giving effect to this Act, and all such other matters and things as may appear necessary or expedient, or are required to be prescribed for effectively carrying into operation the provisions of the Act. And whereas it is provided by Section 34(2) that regulations made under the Act shall be subject to affirmative resolution of Parliament, and whereas the Minister of National Security has, on the 5th day of March 2018, made the Administration of Justice Deoxyribonucleic Acid Regulations 2018, and whereas it is expedient that the Administration of Justice Deoxyribonucleic Acid Regulations 2018 now be affirmed, be it resolved that the Administration of Justice Deoxyribonucleic Acid Regulations 2018 be approved. Madam President, it gives me great pleasure, having successfully navigated the pronunciation of deoxyribonucleic acid on at least 5 occasions, to now refer to that term as DNA for the benefit of all senators and members present. May I say, Madam President, it gives me great pleasure to stand here today to bring to life an aspect of the fight against crime in the area which is sharply pointed to the most vulnerable in society. And that resonates, Madam President, in the ability of using technology which has been tried and tested and developed and practiced in many jurisdictions to the forefront of crime fighting in Trinidad and Tobago. Madam President, it's a fact that Trinidad and Tobago is not new to DNA. It's not new to forensic sciences. Trinidad and Tobago has, in fact, as a country, sat on several occasions, specifically on occasions where this Parliament, both Senate and the House, have been moved to consider the introduction of DNA laws. We started this journey, Madam President, on the 30th of November 1999, when then Brigadier Theodore, sitting as Minister of National Security under a UNC-led government, piloted the Deoxyribonucleic Acid DNA Identification Act 2000. That was dealt with on the 10th of December 1999 in the Senate, and that act was never proclaimed. That act was a feature of deep analysis, then trumpeted to be a potential fillip to the reduction of crime, a weapon in the arsenal of law enforcement to save victims from the trauma of testimony when science could instead give the testimony. And that testimony could be testimony which stands almost on a near incontrovertible basis. Because the DNA facility, the ability to genetically map something with the area of precision that DNA allows, whether it is short chain or long chain DNA analysis and profile creation, allows for nearly over 99% certainty as to probability. When one considers that the criminal standard in Trinidad and Tobago is proof beyond reasonable doubt, that DNA evidence has been held traditionally around the world to meet the standard of proof beyond reasonable doubt. So imagine the impact of telling a victim of a rape, of telling a victim of a sexual offense, of worse yet, telling a child who is a victim of sexual offenses that the evidence can speak for you. And that evidence can be managed and marshaled in a quick fashion. That with a swab, that with the utilization of analysis of a stain of crime scene material, that we can have evidence pointed to an alleged perpetrator, an accused. We can have a certified analysis saying, listen, there's a 99% probability that you are the person who conducted this, and then telling that person, when faced with plea bargaining legislation, admissions of guilt, sentence reduction on early pleas, the host of criminal justice remedies which we, as a Senate, have just recently improved. Imagine the relief that that causes for a child victim in understanding that the law can have the evidence testify for you. But where do we stand today? We're nearly 19 years later from November 1999. 19 years later. But it wasn't only that piece of legislation we passed through. We next passed through Act number 24 of 2007. This particular piece of law was labeled the Deoxyribonucleic Acid DNA Act 2007. We then went to the laws which came in 2012, the Administration of Justice Deoxyribonucleic Act, Chapter 534, which is an Act number 5 of 2012. We didn't stop there. We went to Act number 11 of 2014, which amended the 2012 Act. In getting to this space, the 2007 legislation came about. The 2007 legislation saw the Parliament being invited to consider material deficiencies in the 2000 Act, when a consultant from the United Kingdom was brought on board to advise the government as to operationalization, because that's the key, operationalization of the law. And the consultant, in looking at the 2000 Act, felt that there was inadequate definition of samples to be taken. The procedure for uptaking samples needed improvement. The establishment of databases and the management of forensic DNA science bank had to be improved. And so what we saw was the Parliament enter into discussion. We saw unanimity in the Senate, unanimity in the House of Representatives, with everyone voting yes, as they did in the year 2000. As they came to consider the position in the year 2007, the entire Parliament said yes. But, Madam President, that was 12 years ago. In 2011, we saw the previous government come with DNA legislation, the Administration of Justice DNA Act, which is now being considered before us now. That particular bill went to the House of Representatives. There were voices against the bill then, because the bill as brought to the Parliament ran afoul of a number of provisions. And in the House of Representatives, a then PNM opposition looked at the bill and said, look, number one, you're colliding with the classic case in the European Court of Justice when you're looking at the MAPA principles. I remember vividly when that bill came to the Senate, as I sat in opposition, telling the Minister of Justice then about the MAPA case. He didn't know about it then. He didn't know that 25 judges of the European Court had actually trounced the English position. But in credit to him and to the Senate, we sat and we did surgery to the legislation. As a result of which, we were able, with unanimity in the Senate, to return a bill approved by the entire Senate to the House of Representatives, where it was supported. That, Madam President, was 6 years ago. 2011, 2012, 2013, 2014, 2015, we had the past government undertake to operationalize the law. Collectively across the Ministry of Justice and Ministry of National Security alone, 927,938,071 was spent. Let me repeat that. 22,927,938,071 was spent across two ministries. So what was wrong? Why is it that we took 6 years to consider the operationalization of the law? And I'll say again that the previous government came to Parliament and brought important amendments to the DNA Act. And those important amendments are to be found in the DNA Act as it relates to matters which the opposition then raised. How do you dispose of DNA samples? What about the indefinite right of retention? What about the complainant who no longer wants the DNA profile on the point? What about all of those matters which we advocated as an opposition then were addressed in the 2014 position. The amendments to the DNA Act came as an omnibus element, together with other laws which personally we did not agree with, and therefore then opposition did not agree with the laws which amended this because it came as part of a package. We did not, for instance, believe that certain of the other laws should have been amended. So I want to be careful when you see that there were 5 votes against the 2014 amendments, it was for other reasons, not the DNA Act as the Hansard will show. What happened next? Well, yes, one must always take in front. The point is to set the record straight. We have come now as a government and we've said, this Senate is testimony to what's being done. It matters not how many laws we have on the books of Trinidad and Tobago. It's whether you can operationalize them. The ultimate law of the land is that if you commit murder, you shall hang as a saved sentence. Yet murders happen every day and have happened every day. It matters not how much you make money laundering an offense, how much you make dangerous drugs an offense, how high you climb the penalties for firearm possession. It matters on how many convictions you can have so that there's a fear of sanction, there's a weight of the law. And therefore we as a government have focused upon operationalization at the same time as we legislate. And we'll talk to that a little bit later. But in this DNA legislation, the fact is, Section 34 of the Administration of Justice, DNA Act, Chapter 534 says that you must come with regulations and that those regulations must be subjected to the affirmative resolution of the Parliament. So the Minister of National Security has signed these regulations on the 5th of March 2018, and we went to the House of Representatives and we dealt with the affirmative resolution, and we've come to the Senate now. One clause says you've got to have regulations. Substantively, the Act requires regulations really in 2 specific points. Section 23 has the requirement, and Section 23A has the requirement that you must have regulations. That's it. 2 clauses say you ought to have some regulations. Let's read them. When we look to the Parent Act, we can see that Section 23 says, a person who takes a sample under this Act, and we jump to 23(1)(b), shall ensure that it is properly stored. I'm skipping past several words. We go down to subsection 2(b). The person who receives the package shall record such information as may be prescribed by regulations. 23A, as in capital A, subclause 2, the procedure for keeping of the DNA record shall be prescribed by regulations. That's it. The government could have satisfied the DNA laws at any point in time between 2011 to now by coming up with regulations which match 23 and 23A. Full stop. But that would be to be making a mockery out of the situation. There was a lot more to be done. Because to operationalize this law, you must have certain other elements in place. And the operationalization required, obviously, firstly, the appointment of a custodian. Secondly, the acquisition of data, systems, firmware, hardware. Thirdly, the acquisition of a site to manage the procedures. Fourthly, it required procedures to be adopted. Fifthly, it required the expenditure and coordination in training. And I had a brief chat with Senator Sobers, who mentioned certain aspects about concern, which I share with him. That it's one thing to have the law, but you've got to train people to conduct the law properly, lest the case falls apart through improperly managed evidential routes. And that's a matter of course. You see, in Trinidad and Tobago, we have been stuck. We as a country have been stuck in analysis paralysis on everything. Constitutional reform, judicial management, revenue management, diversification. And let me say why. Sometimes the procedures take a while. Senator Mark is one of the principal advocates for affirmative resolution. But respectfully, we signed the DNA regs since the 5th of March. We're now on the 29th of May. And that's having worked full bore because there are other matters to be taken care of. What I can say is what the cost of not doing this equals. So let me jump to my favorite theme, which is data. I made a vow when I was in opposition that if ever I got the opportunity to address the nation from a governmental point of view, that it should be data-driven. So we know who we are. We know how many child marriages we have. We know how many preliminary inquiries we have. We know how much it takes to upkeep a prisoner in custody for each month. And dare I say, this is the first time Trinidad and Tobago has received data, be it on the energy spotlight, financial situation spotlight. This government has said in its commitment to transparency, let's know who we are first to know where we're going. So let's look to some of the data. The law, the Parent Act, says in Section 15 that protective service people, as whatever they are described, including army, police, etc., across the spectrum, customs, those people are required when you're applying for the job or if you're in the job, you must give a DNA sample and no consent is required. You see, this consent issue is what plagued Trinidad and Tobago in its analysis paralysis. We were afraid as a country to say as a parliament, I'm going to take your DNA sample or your fingerprint without your consent. That's why the 2007 Act didn't launch. That's why the 2000 Act didn't launch. Because we as a parliament didn't want to go far enough in intruding on the rights of privacy to say, I'll take your DNA without your consent. But we did it in 2011, and we did it unanimously. And we did it in 2014, and effectively unanimously, disaggregating the support for DNA from the other bits. So, number of police officers who are mandatorily required to give DNA samples. Madam President, could you let me know the precise minute that I must end?
At 2:54.
Thank you very much. Number of police officers, 6,839. Number of prisons officers, 3,329. Number of persons in the Trinidad and Tobago Defence Force, 5,052. Number of fire officers, 2,190. Number of immigration officers, 375. Number of customs officers, 306. That's 18,091 service personnel. The law goes further than that, mind you, because protective services are also included, meaning people employed in security by their employer can be required to mandatorily give DNA. So we're potentially looking at the entire private security network as well. What does that mean? Let's add some more. Number of convicted persons in jail as of March 16th, 1,515. Number of persons on remand at the same date, 2,317. Again, aggregating 3,832. Why are these numbers here before us? Because in ensuring that Trinidad and Tobago is able to extrapolate and exploit the DNA phenomenon in a positive way, we say let's create a data bank. DNA samples go to the Trinidad and Tobago Forensic Science Institute. They are analyzed there. Profiles are generated. The profile is taken to the DNA custodian. The DNA custodian uploads it into a data bank on an anonymous basis without reference to the personalities, and you have a data bank. 18,091 people, 3,832 people, and the whole private security industry. You're crossing up to close to 60, 70,000 people, potentially. What benefit is that? If you have DNA samples, including ongoing addition of samples for suspects, detainees, deportees, prisoners, aggregating about 1,000 profiles per month, you are looking at mapping Trinidad and Tobago so that when you get to a crime scene, you at least have 60 to 70,000 known profiles. And then it adds. And therefore, if some crime scene is analyzed and a profile is generated, you know who your reference samples are, as the regulations provide, because the reference sample is a very different thing from a crime scene sample. And I'll explain that when I get to Regulation 2 and 3 in just a short while. But when you have these profiles known, you're able to discount the known from the unknown. You're able to find a potential criminal or a potential assistant against a criminal. Because obviously the policeman who's on the crime scene who picks up the sample, his DNA would have to be discounted as a reference sample versus a crime scene sample. And Trinidad and Tobago is crying out for this. What I can say is that the government has retained, under the provisions of Section 9 of the Parent Act, the DNA custodian. The government has managed to lock on board all of the 11 personnel that we need to run. We have the firmware, we have the hardware, and I'm pleased to say today, 15,000 buccal swabs are being cleared through customs as we sit here. 15,000 DNA samples have the potential in a 6-week period to be analyzed by an appropriate laboratory and uploaded to the database. 1,000 detainees per month have the ability to go onto the DNA database. That means that after 19 years of analysis paralysis, we are able to operationalize the laws. I mean, surely we must abhor the situation of having laws on the books of Trinidad and Tobago without them being operationalized. Let's look further. Let's look to further statistics. Let's look to the number of persons convicted in a subcategory of offenses for sexual offenses for the 19-year period. Let's take 18 years, 2000 to present. There have been, in terms of offenses, cases reported, listen to the number, 13,630 sexual offenses cases. Number of persons convicted of that 13,000, a whopping 321. Number of sexual offenses cases solved using DNA evidence from the year 2000 to present. Guess what the number is? 0. 19 years of law, 4 sittings of Parliament, times 2 because it's Senate and House, add 10 sittings of a JSC, add billions of dollars between national security and other ministries, and we have 0 convictions on DNA evidence. 0 for sexual offenses only. This does not include murder, which could easily be another subcategory fit for analysis. We're talking about sexual offenses only. We saw in the papers the memory of Akil Chambers, who would have been 31 years old, but DNA evidence is available from that site. And that unknown perpetrator could have been brought forward as they found evidence of sexual abuse of, God rest his soul, that beautiful young boy found on the bottom of a pool. But 19 years later, no operationalized DNA laws. Number of DNA samples sent, we've got a number for that. We have cost of services. We're sharpening our pencils. And let me tell you this. You know how much the DNA profile kits cost us, the buccal swabs? A massive $20 TT per kit. $20 TT per kit. Billions spent. Lots of old talk. So I think I've established the point that we must be intolerant to any more delay. So let's get to the regulations. We propose in the regulations before this Honorable Senate for affirmative resolution that we address more than just the 2 mandatory provisions of the Act. Section 34 says you must have regs, affirmative resolution. We are now here assembled. Section 23 and Section 23A say what we must have regs for. We've traversed that. We say, most respectfully, that we ought to provide for at least 8 other factors. 1, we should provide in the regulations for a distinction between reference sample and crime scene material. 2, we should expand on the role and responsibilities of the custodian, especially in establishing the minimum standard criteria and moving a little bit beyond. Thirdly, we say the procedure for taking samples from the category of persons that we ought to consider ought to be particularly careful when we get to the concept of the complainant. For non-lawyers, the complainant is the person who is the victim of a sexual offense. The complainant is set out at Section 18 and Section 19. We deal with children, and Section 20 of the Parent Act, and we treat complainants very differently from everyone else, where we require the complainant to give express consent to the DNA sample because we don't want to re-traumatize a victim of sexual offenses. We say next, as the fourth limb, that we should establish procedures for searching the National Forensic DNA Data Bank. We anchor back to Sections 10 and Section 24 of the Parent Act. We say, as a fifth ground, that we ought to address matters relating to the DNA register of the Trinidad and Tobago Forensic Sciences Institute, and we hearken back in terms of a springboard for legislative authority to Section 5 of the Parent Act. We say, sixthly, that we ought to expand the requirements under the Act for the storage of reference samples and crime scene material. And we look specifically, that's where the mandatory provisions for regulations come in, Section 23(1)(b), Section 23(2)(b), Section 23(a). We also link it with Section 25 of the Parent Act, which relates to the keeping of samples, and Section 26, which treats with the destruction of samples. Seventhly, we propose that we provide for early submission of reference samples and crime scene materials and the conditions under which they are transported to the Forensic Sciences Institute. Why? You don't want to destroy the evidence. You want to make sure your chain of custody issues are kept. You want to make sure that there's no break so that the evidence is sabotaged because proper procedure wasn't managed. The person who took the sample must manage it in a secure way until the storage happens. It must be stored under careful conditions. After storage, the profiling must be done by transportation to the Forensic Sciences Institute. When analyzed there, records must be kept and sent back. Then the profiles generated go to the DNA custodian, and then the search parameters, etc. We must always be diligent to be methodical in managing evidence, because if you don't have evidence, you don't have a conviction or you don't have an exoneration, both of which are equally important. As a last matter, we say we ought to address privacy, security, and access issues, which in our view weren't adequately addressed in the parent law. And in particular reference, we've harkened back to Sections 26, which deals with expunging of files in the Parent Act, Section 29, which is disclosure and confidentiality, and then we've looked at the offenses in Sections 30 and 31 of the Parent Act. So those are the essential 8 broad areas covered in the regulations, and what we propose is that we're assisted in treating with the regulations by managing the information and processes in a logical and clear fashion. Honorable Senators, is this a perfect regulation? No. Is there any one perfect piece of law? No. Can it be worked upon and improved over time? Yes. Is there precedent for that elsewhere in the world? Yes. We've had a problem in our jurisdiction of people just starting. We're always invited, let's discuss some more, let's have more discussions. Let's come up with a perfect product. What about this? What about that? Well, what about starting? What about getting past 19 years of talking and starting for the 13,000 sexual offenses? So let's get now to the regulations themselves. Let's look to the specifics of the regs. We start by noting that the regulations are 10 parts long. They consist of 30 regulations, and there are 3 schedules. Obviously, the regs articulate with the Parent Act, which is why I've taken time and care to reference honorable members to the springboard provisions in the Parent Act. We have divided them into preliminary issues. That's in part 1. We deal in part 2 with roles and responsibilities of the custodian. In part 3 with the taking of samples. In part 4 with analysis. Part 5 with searches of the data bank. Part 6 we deal with the records. Part 7 we deal with the storage of reference samples and crime scene materials. Part 8 we deal with transport. Part 9 we deal with privacy standards, security and access. And part 10 we treat with the miscellaneous provisions. And then the 3 schedules treat with the specifics of the forms and procedures that we adopt, which are broader than the 4 schedules that appear in the Parent Act. I refer honourable members to Clause 2, Regulation 2. Regulation 2, and this is going to be a bit difficult because we don't have a committee stage on regulations that come for affirmative resolution. That's not what we're doing today. So, honourable members, I know it may be hard to have all questions answered. So sometimes in your submission, if you've asked a question and you want to have a reply from me specifically, I'd ask you to allow that opportunity. I don't consider this a combative debate on this particular one. I think we are of equal purpose, that it's high time that we dealt with it. Regulation 2. I ask honourable members to note crime scene material and crime scene material register is to be factored in mind against reference samples and a reference sample meaning as set out. Let's give this in the context of sexual offences. A reference sample, as it's set out in the regulation, is a sample whose origin is known and which can be compared with a DNA profile. A crime scene material is any material taken from a crime scene. We have proposed that we step beyond the data record phenomenon. In Clause 4 of the Parent Act, you'll see the expression data record. A data record is the thing which you must keep at every place where you collect DNA. Police station, hospital, prison, deportation at the immigration centers. Everywhere you treat with DNA collection, you have to have a DNA record. We've gone a step further to say you need to have a crime scene material register and separate it out from a known register. So we're therefore introducing the differentiation between reference and crime scene material because of the complexity of treating with sexual offences cases. If you looked at the definition of crime scene in the Parent Act, crime scene can include anything contained within a body part or the human body. And therefore, in particular, in sexual offences matters, you may take one sample which may be both a reference sample and evidence in the crime scene. And therefore, it is important to disaggregate those two in a more logical matrix in keeping with what we have done in other jurisdictions and which we have taken judicial notice of as these regulations, legislative notice of, as we have done in these regulations. I ask honourable members to look at Regulation 3. In Regulation 3, Regulation 4, 5, and 6, under Part 2, we're treating with the roles and responsibilities of the custodian. The custodian's roles and responsibilities are set out in Section 10 of the Parent Act, but they were a little bit limited. We felt that the regulations as subsidiary legislation provided a very good opportunity to broaden and expand the positions of the roles and responsibilities of the regulator, and we have specifically added into that pack that there should be an expansion. We've added in ensuring that data is accurately loaded into the National Forensic DNA Data Bank. We've added in that there's to be a conduct of an annual on-site visit to the Forensic Science Center to ensure that it has capability to perform the requested DNA services. And we've added in that we should accept DNA profiles and documentation generated from the Forensic Sciences Center and approved laboratories under Section 6 of the Act. So we've broadened the scope. And we've done that knowing fully well that the government is currently in the middle of perfecting a brand new forensics institute, which the Honourable Prime Minister will no doubt speak to in the course of his press conference that he's talking about today. So I'll leave that for another occasion. Madam President, we believe that Regulation 6 is important, and we've allowed for the custodian to develop effectively standard operating procedures or soft side descriptions of technology improvement, which are not prescriptively set out here. And we do so because we don't want to have technological specificity stymie the growth of the area when constitutionally it is open to a commissioner of police or to a DNA custodian to develop these standards by him or herself. I'd like to specifically draw in aid for support the case of R, open brackets, GC, close brackets, versus the Metropolitan Police Commissioner. It's a 2011 All England Law Reports case at page 580, at 859, where the Supreme Court of the United Kingdom opined in its majority judgment, Parliament is entitled to give the police the power to create a scheme. No doubt it would have envisaged that a national scheme would be produced as such a part of guidelines. Secretary of State is accountable to Parliament, etc. And then they go on to say at paragraph 43, there is no reason in principle why the police, together with Secretary of State, should be less well equipped than Parliament to create guidelines. And therefore we lend our proportionality and ability to avoid technological specificity by calling in aid the ability to allow the custodian to develop best practices, published as the regulations require, gazetted as the regulations require, and upon which there is training as the regulations require, so that we can fall in aid for development of the law as it progresses. Similarly, we look to part 3 now. When we look to part 7, regulation 7, here is the center point upon the complainant. Remember, complainant is not your average plaintiff or claimant, as we call it in the civil law. A complainant here is a specifically defined term under the Parent Act, which refers to the victim or the alleged victim of a sexual offense. We've again put in terms of the process flow the application of the use of a qualified person and how the material is to be treated with. Regulation 8 treats with taking of reference sample and retrieval of crime scene material by a police officer or qualified person. That harkens back to section 13 of the Parent Act, where we are looking again to this concept of the DNA record and in particular the register of crime scene material, making sure that we have records of how we treat with data for an evidential purpose and utilization. Regulation 9, Madam President, you said 53 or 57? 54. I must hustle. Regulation 9, we treat with taking of a sample from a person admitted to a private hospital. We then adopted the same process and flow. We go to 10, which is the taking of a sample from a person in prison. So we're again dealing with all of the subcategorizations of Section 13. Section 13 sets out the broad range: prisoner, detainee, suspect, security aspects, persons from whom samples can be taken without consent. That is to be married with Section 15, which treats with your protective service personnel. When we get to Regulation 11, we're taking a reference sample at a port of entry. Again, that's back to Section 13, detainees and deportees, etc. When we get to 12, we're looking at taking a reference sample for a person detained in a child rehabilitation center. Obviously, there was an amendment away from the description of juvenile centers. When we did the Family and Children Division amendments, we removed the concept of juvenile offenders and we turned instead to children in that category, children in need of care or child offenders. We've dealt with in part 4 with the analysis provisions. And there are 2 sections there. Very important.
Attorney General, you have 5 more minutes.
Thank you, Madam President. Analysis of reference samples and crime scene materials is at Regulation 13. And what we're doing here is making sure that the reference samples are handed over in prescribed fashions. But in 14, that's where we find the anonymity of DNA profiles, a major safeguard to make sure that the Forensic Science Institute has one limb of it. They know the sample, who it's from. When the profile is generated, only the profile goes to the DNA custodian. Because when the DNA custodian is doing a match analysis, you don't want the risk of prejudice entering the mind of the DNA custodian. Part 5 treats with searches of the data bank. And Regulation 15 really prescribes 10 steps of how we treat with analysis. In summary, the analysis is when you get the profile, run a search every time when you're loading. So as you're loading up something new, run a search every time to see if you know who's on it. Secondly, run where requested. Run a search where a request is made. Thirdly, search even though you have a poor quality sample, because you may get a hit with a partial sample, which can then be drilled down with circumstantial evidence otherwise. Fourthly, don't upload poor quality sample data. You can search it, but don't upload it, because we don't want to add untrustworthy information. Fifthly, where you have a duplication, let us know. Was somebody mislabeled? Is it a genetic twin? Was it an uploading error? Was somebody tampering with the evidence? And when that happens, commission a police commissioner's inquiry as a matter of immediacy, so that the turpitude of manipulation or errors are treated with in a logical fashion. We treat with duplication information, that we remove duplicates where it's found. We treat with the phenomenon of genetic twins, so that fact and reality of duplication of DNA can be treated with. And then we deal with match reports, how we send to the Forensic Sciences Center and how we send to the Commissioner of Police, so that again we trace in a logical fashion this material and process flow. We deal with forms and we deal with reports. So Regulation 15 is a biggie. It's an important provision which has a number of safeguards managed in the process. Part 6 treats with records. Sections, Regulation 16, 17, 18. We deal with where we keep records straight down to 23 in every institution that Section 13 requires. Section 13 of the Parent Act gives multiple platforms. The regulations now treat with the steps that are to be taken in the management of records, so that every location we have records that can be matched up in a court of law. We deal next with Part 7, which is Regulation 24, storage of reference samples. I want you to note here, we have not prescribed temperature, location, management, because what happens if the sample technologically can be managed elsewhere? Again, we fall in aid to the Metropolitan Police Commissioner 2011 case, where that is a proper matter for guidelines. Remember, there's a safeguard for publication and gazetting of these guidelines. Is it perfect? No. It does depend upon training. It does depend upon resonance of training throughout the process. But legislatively around the world, this is the way it is treated. We treat with transportation in Part 8, where you're transporting and you're delivering samples. We treat in Part 9 with privacy standards and access. Privacy standards are in Regulation 26, where we deal with the encryption, end-to-end encryption bases, so that we run the less risk in turpitude finding its way through from manipulation of systems. We deal with DNA disclosure in Regulation 28, and then we get down to the miscellaneous provisions, which is an important but practical step in how we manage records, where the original is kept, where the counterpart is kept. 30 seconds left. Honorable members, it's high time. It's been 19 years. It's been billions of dollars. It's been thousands of cases. This Senate is faced with an excellent opportunity to just start. Just start. Get a fighting chance. It applies to sexual offenses. It applies to murder. It applies to any place where forensic material may be used. Madam President, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is, whereas it is provided by Section 34(1) of the Administration of Justice Deoxyribonucleic Acid Act 2012, hereinafter referred to as the Act, that the Minister may make regulations for the purpose of giving effect to this Act, and all such other matters and things as may appear necessary or expedient, or are required to be prescribed for effectively carrying into operation the provisions of the Act. And whereas it is provided by Section 34(2) that the regulations made under the Act shall be subject to affirmative resolution of Parliament. And whereas the Minister of National Security has, on the 5th day of March 2018, made the Administration of Justice Deoxyribonucleic acid regulations 2018, and whereas it is expedient that the administration of justice Deoxyribonucleic acid regulations 2018 now be affirmed, be it resolved that the administration of justice Deoxyribonucleic acid regulations 2018 be approved. Senator Mark.
Madam President, I'm very happy and pleased to rise and speak to the regulations governing DNA. I wouldn't go through the entire word. I'm very familiar with it. So I am dealing with the DNA regulations of 2017, which would address the collection, the transportation, the storage, and most importantly, Madam President, the entering into the DNA data bank of DNA samples or other related matters relevant to that process. Now, Madam President, before I go into my contribution, I want to indicate from the outset, we would like to stand very firmly with the Attorney General, but I want to let him know that we do not stand, and we do not like to stand on quicksand. These regulations leave a lot to be desired. And we intend to propose several amendments to these regulations as we proceed. But I will explain as I go further, why we see deficiencies, weaknesses, shortcomings in these regulations that are before this Honorable Senate today. Madam President, may I set the record straight? The Attorney General indicated, and maybe it might have been a genuine error on his part, but may I remind the Attorney General that the opposition then PNM, even with the amendments, first of all, they voted against the bill of 2012 in the lower house. But you also misled this parliament. All right, okay, all right, okay. All right, he made a statement to the effect. Madam President, yes, I'll try, Madam. Yes. Madam President, he did make a statement to the effect that when it came to this house, they spent considerable amount of time amending, and when it was returned to the other place, it was unanimously agreed upon. Madam President, the record is showing, and that is why technology is so important. The record is showing that every single member of the PNN opposition voted even against the amendments. Every single one of them, I have their names here, and the date of that exercise, Madam President, is Thursday, April the 26th, 2012. It is in the Hansard record. So don't come and tell this parliament that the PNM voted unanimously, both in the Senate and in the House. That is wrong. So I needed to correct the record, Madam President. So please, don't try that. Don't try that, especially when I'm here. Try that when I'm absent, not when I'm here. Madam President, the second thing I want to just bring to my colleagues' attention is a simple thing. It was in a Newsday article of it was the 6th of March, 2018. At that time, the Honorable Attorney General was addressing or launching something called Model Guidelines for Sexual Offense Cases in the Caribbean region at the Hyatt Regency. And my honorable colleague, the Attorney General, did indicate at that time that some 15,000 DNA kits were en route to Port of Spain. That was 2 months, Madam President, and 10 to 11 days ago. Now the AG addresses us today. He said, as he is speaking, those DNA kits are being cleared at the customs level, and I'm happy that it took longer almost than the Fatal Razak to arrive here. Longer than the Fatal, and I don't know about the Galleon Passage, because we are in trouble with that. So Madam President, here it is. We have this, these kits, DNA kits, now arrive, and I'm happy that they have arrived. And as he said, they are being unloaded right now in Port of Spain at the customs level. We are happy about that, Madam President. Madam President, may I indicate to you that this matter I want to deal with, first of all, addresses the custodian, the role of the custodian. And I also want to spend some time dealing with the Forensic Science Center, Madam President. But before I do so, Madam President, I want to share with you some of the importance of ensuring the independence of the office of custodian. That is a very important office. And even the legislation talks about its independence, Madam President. Madam President, when you're doing DNA samples and profiles that are generated from those samples, you are dealing with people's privacy, Madam President. And therefore, the whole question of security and safety of those samples become very critical and very important. So we need strong security measures, which are largely absent in the regulations here. We are seeing some very vague, it's like the doctrine of vagueness permeating throughout these regulations. As soon as possible, Madam President, as soon as it's practical, you cannot deal with DNA in that kind of manner. We have to be more serious. So, Madam President, we are advancing that strong security measures must be implemented to ensure that the information on the database is used for the permitted purposes set out in the legislation and now in the regulations. Madam President, the government requires stringent and effective safeguards in these regulations if we are to put in place and to ensure that the biological samples which are to be stored are stored in appropriate and secured conditions, Madam President. Madam President, it is therefore very important that the custodian, which is the custodian, Madam President, you would see in what I call Part 2 of the regulations, deals with the roles and responsibilities of this office holder. All we are told, Madam President, and I'll come to that in a short while, is that the government has engaged a custodian. We don't know when, but I know when it was, because it is in a report that was generated by the Joint Select Committee on National Security. So we have the date when the custodian came on board. So we know the custodian has been on board since January of 2017. They brought a custodian on board. Madam President, do you know, in the legislation, as well as the regulations, we do not know what are the qualifications and or credentials of this custodian. We don't know if he's a scientist in genetics. We do not know if he's a molecular biologist. We don't know what is the background of this individual. And the Attorney General spoke for his entire 40 or 45 minutes, and he did not let us know who is this person, where is this person from. I understand the person is from Jamaica. Well, I'm a Caribbean man, so I welcome Jamaica. But let us know if that is true. Madam President, is the custodian a Jamaican?
Mark.
Madam President?
I'm sorry, but I do have to interrupt here a little bit. We are dealing with the regulations.
Yes.
The Act, the Principal Act, sets out the custodian, how the custodian is to be appointed. The regulations are dealing with something different. So whether the custodian, where he's from, that is not relevant to the issue that we are dealing with, to the regulations, okay?
Madam President, this is law that we are passing here, you know. And if we are passing law that is going to impact on the rights of citizens of this country, you are going to be asking people, as the Honorable Attorney General has indicated, Madam President, that close to, he talked about 70,000 citizens who will be forced without their consent to give their DNA samples, Madam President. And we here are passing these regulations, so they would like us to support those regulations. And we are talking about the roles and responsibilities of a custodian. And what we are saying is that we would like to know, and I thought that was a legitimate area, but I'm guided by you, Madam President. That is an area, Madam President, that we wanted to get some clarification on. We would have wanted to get some clarification on how is this person, Madam President, if he's to maintain his independence to carry out these roles and functions, Madam President. Madam President, hear what the regulation says, that the custodian shall ensure that all data entered into the data bank is accurately loaded at time of entry into the data bank, Madam President. Right? It goes on to say, Madam President, the custodian shall at least once a year conduct an on-site visit at the Forensic Science Center to ensure that the Forensic Science Center has the capability to perform the requisite DNA service. Madam President, how is this going to be executed? This custodian is going to be operating from where? The Attorney General did not tell us where. All he said is that there are 5 critical areas. He talked about custodian, he talked about location, he talked about equipment, he talked about 2 other factors, technology as one, and expenditure and training, Madam President. We are being told that this custodian is going to be responsible for entering into the data bank all these samples, Madam President. But nowhere in the section that deals with the roles and responsibilities of the custodian are we told what are the standards that will guide this individual. So what we are seeing, Madam President, in 4.1 of Part 2, all we are told is that the custodian shall, from time to time, set the minimum standards in accordance with international best practices for entry onto and removal of data from the data bank, which shall be published in the Gazette. Madam President, we are passing laws. you are going to take samples of accused persons, of suspects, of detainees, of prisoners, of deportees, persons of interest to national security, Madam President. And we are being told that the custodian will be able on his own, Madam President, to establish minimum standards. Madam President, don't you believe that we should have sight of those standards? Because I understand that this custodian has been engaged for 1 year and almost 2 months now, or maybe 3 months. Should we not have some minimum standards before us so that we are dealing with regulations, and we would like to know what are the minimum standards that are being set by this custodian and his deputy? Madam President, what is even more alarming is that this custodian is appointed by the executive. No, hear me. We are talking about the independence of samples. Madam President, do you know that samples can be fabricated, can be contaminated, can be intentionally compromised, Madam President? These are real situations. You are dealing with people's personal lives. You are dealing with people's personal characteristics. And if you do not have proper systems in place, Madam President, you are going to compromise people's personal security and safety in the country. The victims are important. I'm not arguing that. But let me tell you something. People have anyway, let me not take him on. I agree with you. Let me just don't take on the gentleman. He's here temporarily in any event. So, and he causing trouble already. But anyway, Madam President, what we are advancing here is simply this, right? Here it is, Madam President. It goes on to say, Madam President, the custodian shall at least once a year conduct an on-site visit to the Forensic Science Center. Madam President, I would have liked the Attorney General to tell us if the Forensic Science Center has been accredited under ISO IEC 17025 standards. Madam President, I would have liked to know this. Because, Madam President, if you are certified and accredited, standards are established for you. But if you are not accredited, Madam President, anything can happen. And not only that, Madam President, this individual, the custodian, is being asked to go to this center, the Forensic Science Center, at least once a year to ensure everything is, the requisite DNA service is in place and etc. But, Madam President, there is no provision in the regulations for this gentleman to visit the private laboratories. Who is going to establish the standards, Madam President, for the private laboratories? Who is going to visit those private laboratories? Not the same custodian, Madam President? But how come in the regulations, there's no provision in the regulations for this gentleman to go to these private laboratories to ensure that the standards that are set and established at the Forensic Science Center to deal with DNA sampling, how come he's not extending that to those other private laboratories that will be conducting sampling exercises on behalf of the government? That is missing from the regulations, Madam President. That is why I said that we have to propose certain changes to these regulations. In their current form, they can't stand, Madam President. So, Madam President, we are seeing where the custodian has a lot of power, and we have no problem with that because he has a very critical role and responsibility to exercise, and we expect that. But, Madam President, when we look at Section 4.1 of the regulations again, we find that, for instance, it is purely subjective, it is discretionary, and, Madam President, why are we seeking to establish minimum standards? Why are we seeking to establish the minimum standards? Why don't we establish standards that are acceptable in terms of international best practice? But we are going to what is called minimum standards. Madam President, here what Section 4, subsection 2 of the custodian, the section dealing with roles and responsibilities of the custodian. Here what this gentleman does. He sets standards under this regulation, and standards shall be observed for the entry and removal of data in the data bank. He has the power to reinstate, suspend, and amend DNA profiles in the data bank, and he has the power to search the data bank. This custodian, Madam President, has a lot of power. The question here, what are the mechanisms in place in these regulations to ensure proper accountability, Madam President? In other words, Madam President, to whom is the custodian accountable? To whom is the custodian accountable? Is he accountable, Madam President, to the Minister of National Security and the Cabinet who appointed him? These are areas and so on that we are concerned about. And Madam President, when as you proceed, you see the kind of power that this gentleman has in this whole arrangement. Madam President, may I advise that when you look at the South African DNA regulations, you will see where in those regulations there are serious standards that have been established under the regulations under the South African arrangement, where we don't find the same standards being established under the arrangement that we are now examining as it relates to the custodian, who is going to be visiting at least and conducting at least once a year a site visit, Madam President. That is an area that we have some concern about. So we are saying when we look at the standards that have been established by the South Africans, we look at the United States in terms of Rhode Island state, we are seeing, Madam President, some very solid, robust standards that are being established to ensure that there are proper systems in place to avoid any tampering, any contamination, any fabrication, or any compromising of those samples that are being provided, Madam President. Madam President, I am very happy to report that when I looked at the National Security Committee report, they reported since in 2016 the need for the government to bring regulations to this Parliament. Madam President, that was since June and July of 2016. We are today, based on the 5th of March, the signing off of these regulations, we are now dealing with those regulations in 2018. So for 2016 to 2017, 2017 now to 2018, almost 2 years, Madam President. What was the executive doing as it relates to bringing these regulations to the Parliament so that we can use it as a tool to fight crime in this country? Madam President, the Forensic Science Center, which is very critical in these regulations that we are debating today, that center, Madam President, has a lot of challenges. And that is why I was hoping that the Attorney General would have told us. He said when the Prime Minister comes this evening from his visit abroad, he will bring us up to speed with a new laboratory. But, Madam President, we read in the literature that some 5 years ago, a center was supposed to be established in Carson Field. but nothing has happened. And I would like to know where this new center is going to be established. Do we have to wait until the Prime Minister tells us about it? But, Madam President, I want to also indicate to you the importance of ensuring that we have proper standards. So that, for instance, people's DNA samples would not be compromised, Madam President. The Honorable Attorney General, Madam President, made reference to this young man who would have been 31 years today had he lived, the young Akil Chambers. Madam President, I read with shock and somewhat, almost, it is almost incredible to believe that from the Forensic Science Center, if the report in the Express turns out to be true, swabs that were taken of this child at that material time just gone missing, Madam President, from the Forensic Science Center. They say that there was an underwear, a shorts. Yeah, but what I'm saying, I'm just showing to you, telling you, Madam President, that the center seemed to be a hotbed for all kinds of activities. So they steal material from the center. The center is understaffed, Madam President. There are thousands of matters that are pending at the center. And this is the same center that we have now officially designed or designated as the official center for DNA sampling and for the establishment of the DNA database, Madam President. That is the center. So, are we serious, Madam President? I don't think we are. These are very serious matters that we are debating this evening, Madam President. Madam President, I want to ask you and invite you to look at page 6 of these regulations, where we are told that persons can be detained, right, Madam President, by a qualified person or a police officer or a police officer and or a qualified person, okay? If you are coming into the country, Madam President, you can be held at the chief immigration officer level, right? That is the port of entry, or which could be the place of detention. Madam President, so you are coming into Trinidad and Tobago, you can be detained at the port at the pleasure of the chief immigration officer, who shall arrange, according to the regulations, to have a qualified person to attend to the port of entry or place of detention for purposes of taking a sample. Madam President, nowhere in the regulation does the government or the minister, the Attorney General, tell us whether the infrastructure is in place, Madam President. What kind of infrastructure would be in place to facilitate this arrangement? Madam President, not only that, when somebody arrives at the port and they are detained, how long, what is the time frame it must take for the chief immigration officer to get a qualified person to take that person's DNA? That is absent from the regulations. Madam President, you go to the area of whether it's a rehabilitation center involving children, whether it is a psychiatric ward or hospital, Madam President, what you have, Madam President, is a situation where there are no specific timelines given for the taking of DNA samples. Everything is up in the air. Everything is as soon as possible, Madam President. You cannot run an administration like that. And when you go to the South African regulations and you go to the regulations out of the United States, Madam President, there are specific standards and there are specific timelines that you must satisfy. We have left it open and loose, Madam President. How can that be justified and be fair, Madam President? Even though, as my colleague said next to me, opposite me rather, that what about the victims? And in other words, the people who have committed the crime, they must do the time, and they have no rights. Forget them. Madam President, we don't live in that kind of society. Everyone has rights, even though they are convicted. But for the PNM, anytime you're convicted, you have no rights. And this, the gentleman who made the remark is a lawyer. Sorry, ma'am. I'm sorry about the lawyer. Yes, the honorable member of the Senate, who is an attorney at law. Yes, and I was surprised that he would have made that statement. So, Madam President, this is an issue that we are concerned about because we are not getting from these regulations, Madam President, any specifics coming from the government as it relates to this matter, Madam President. So these are areas that we would like to have some further clarification on, Madam President. Madam President, we talk about information technology. What is the technology, Madam President, that will be introduced to effect this measure? You know, the Attorney General didn't tell us. All he said that equipment has been purchased, technology has been purchased, and the Prime Minister will report. But the Prime Minister is not in the Parliament. We want to get answers, Madam President, on these matters. Madam President, you know who are the people who are qualified to take samples? Any police officer and a qualified person, either a medical practitioner or a registered nurse in accordance with the relevant act. Madam President, the question I want to pose to the Attorney General, who is not here, I would like to ask, Madam President, through you, what kind of training are these police officers going to be experiencing? Have these police officers been given the appropriate training and they have been certified by the appropriate institution for the taking of samples of citizens of this country, even though those citizens may have offended the law? Madam President, I am not seeing these things in the legislation. So we don't know if these policemen, well, Madam President, I don't know. I read with alarm this morning where somebody who has been charged was charged under the wrong law. And that is a simple matter. So if you're charging somebody under the wrong law, which is a simple matter, and you are trained and you're supposed to be there for a number of years, what would happen, Madam President, when you have introduced new legislation and these are the people who are supposed to be taking DNA samples of citizens of this country? Have they been trained, Madam President? Madam President, there are technicians involved. There are analysts involved. There are police officers involved. There are nurses involved. There are doctors involved. They are supposed to be trained, Madam President. They are supposed to be certified. But where is the evidence here? Did we get that from the Honorable Attorney General's submission? We didn't. So we don't know, Madam President. We don't know what is going on with the technology, Madam President. And Madam President, you know and I know when you engage in the actions that this government is about to embark upon, we want to make sure that the rights of the citizens are not infringed unnecessarily. Everyone has rights, and we have to protect those rights, Madam President. So that is an area, Madam President, that we would like to have some clarification. Madam President, I go to page 8 of this report. And Madam President, this one is frightening. I want to read it very slowly so that, Madam President, you'll understand the slipshod approach that this government is taking when it comes to this question of DNA regulations and DNA sampling. Madam President, hear what the government is saying in Regulation 3 on page 8. Notwithstanding the fact that a DNA profile, that is after you put in your sample, you have your sample, from your sample you get a profile, and you input that into the system, Madam President, and a number emerges. They are saying, notwithstanding the fact that a DNA profile does not meet the minimum standards for loading onto the data bank, the custodian may, at the request of the Commissioner of Police, an investigating officer, or the central authority, conduct a search of the data bank against the DNA profile. So, Madam President, here it is.
Senator Mark, you have 5 more minutes.
Yeah, Madam President, so far? Madam President, imagine DNA standards are at a minimum. And even with minimum standards, Madam President, they are saying to this Parliament that the custodian, even though the profile, the DNA profile, does not meet the minimum standard, he, once a request is made by the Commissioner of Police, an investigating officer acting in the course of a criminal investigation, or the central authority, they shall conduct, that is, the custodian shall conduct a search of the data bank. Madam President, how serious are we? We are not guinea pigs, you know, that are on an experiment. We are dealing with human beings who have human dignity. And you must protect people's human dignity in spite of whatever offenses they might have committed, Madam President. So, Madam President, we are very, very, very concerned about, and Madam President, there is a provision that says the custodian, where he's informed by the Commissioner of Police of the source and reason for the duplication, devoid of any personal information, he shall take all reasonable steps to remove the duplicate DNA profile. What does that mean, Madam President? It goes on to say that the custodian shall, as soon as possible, prepare a match report and issue the match report to the investigating officer. Madam President, it is as soon as possible. Take all reasonable steps. Madam President, these are vague expressions. We cannot be serious. The government cannot be serious to bring this here this evening and expect us to pass it with blindfolded. You can't be serious. So we are going to be proposing at the appropriate time several amendments to strengthen these regulations, and we will submit them to you, Honorable President, so that you will have sight of those amendments, because we believe that as legislators, as lawmakers, we are here to strengthen legislation and to ensure that there are standards, that there are procedures, that there are safeguards, that there is security, Madam President, for all and sundry in this country, and not allow, Madam President, people to simply exploit circumstances and situations. Madam President, there are several instances where DNA has been fabricated, contaminated, compromised, and innocent people have been jailed and sentenced and put away for life, Madam President. And we can't allow, because the government says so. They bring regulations and say, well, look, we must pass it. No, we're not passing regulations just so, Madam President. We are saying that we want to help the government. We want to get this thing working. But we want to ensure, Madam President, that the regulations are robust and they can stand the test of time. That is what we want to ensure, Madam President. Madam President, there is so much that we have to say, but I can't take up everybody's time. So I will have to rest my case. But I will tell the government that do not bring weak, deficient, unacceptable regulations to this Parliament and expect a blanket support from the opposition. We are going to do our duty to the people of this country. We are going to strengthen legislation. We are going to submit amendments to you, Madam President, to make sure that we strengthen this legislation through the regulation so that we'll have a better arrangement at the end of the process, Madam President. Madam President, as I said, I can pass on to you and to this Honorable Senate the DNA regulations of South Africa, the DNA regulation of Rhode Island State, and also the Jamaican legislation, and to see the standards that they have set, Madam President. Madam President, I want to thank you for giving me the opportunity to make my contribution. Thank you very much.
Senator Shrikissoon.
Thank you, Madam President and colleagues. As we assemble here today in this honourable House to debate the regulations concerning the DNA Act of Trinidad and Tobago, and I think the latest edition would be 2014. Madam President, today is indeed a very important date for me in the life of using DNA in Trinidad and Tobago. But I have noted that in 2012, the 2007 Act was repealed, and in 2014, amendments were brought to the 2012 Act, which really demonstrates, or which really places DNA or positions DNA for use in the courts of Trinidad and Tobago. And as I begin, because of that time, we were being governed by a different political party. I wish to commend the efforts of the last administration in really amending the DNA laws so that it can be more relevant and more appropriate in determining or in the administering of justice in Trinidad and Tobago. So I do think they need to be commended for that, and I acknowledge their efforts. The Attorney General, in his opening presentation, outlined the many functions and use of DNA in Trinidad and Tobago, and I too would just like to touch on a couple of benefits of using this DNA legislation, or allowing this DNA legislation to be enacted in Trinidad and Tobago. Because one of the primary benefits of DNA is that no two persons would have the same DNA profile, probably except in the case of identical twins, maybe. And DNA evidence collected from a crime scene can link a suspect to a crime or eliminate one from suspicion of having performed that crime. It can also be used to identify relatives of a criminal or someone who was related to the criminal or the person involved. It can be used to match a suspect to a crime scene, or for one single person to link one single person to multiple crime scenes, or even those involved in performing sexual assaults and other violent crimes. In Trinidad and Tobago today, we have a significant problem with crime, and therefore, if this piece of legislation helps us administer justice, then so be it. I welcome it. Just in a matter of reflection, and just for a minute or two, I just would like to reference one statistic, and that is that of the murder rate of Trinidad and Tobago over the last 5 years. In 2013, we had 408 reported murders. 2014, 403. 2015, 420. But I just would like to report against these statistics the murders that have been detected. So in 2013, while it was 408, it was just 56 detected in 2013, a detection rate of 14%. In 2015, was 420 reported, 57 detected, just about 14%. And in 2017, 495 reported, 89 detected, just about 18%. What is my point with this? My point is saying here, we have a runaway murder rate, as in other areas of crime, but our level of detection is extremely low, and it's not even touching 20%. And therefore, if this piece of legislation can assist in the detection of criminal offenses and offenses against the people of Trinidad and Tobago, then I would support it because it has its place. I can quote the statistics for breakings and robberies as well, but I don't think we need to go into that because the statistic on murder clearly demonstrates that we have a low detection rate, and therefore, as a country, we need to address this. And an increase in detection rate on its own can serve as a prohibition against criminal offenses. Madam President, with respect to the regulations here before us today, the regulations before us is divided into a couple sections. And it pertains to the roles and responsibilities of the custodians, taking samples, analyzing profiles or samples, searching the data bank, records being held, storage of samples, transportation of samples, privacy of information, and a miscellaneous section. So the regulations before us is quite comprehensive because it addresses a number of areas. Madam President, at the beginning of the regulations, Clause 3.2, and Senator Mark touched on it briefly, it says here that the custodian shall at least once a year conduct an on-site visit to the Forensic Science Center to ensure that the Forensic Science Center has the capability to perform requisite DNA service. I am saying here, if this level of service and this level of analysis and this level of research is so critical to Trinidad and Tobago, then I'm a little bit concerned that we are only going to do this at least once a year. And I know that the interpretation of at least can be more than once. But I am of the belief that the custodian shall ensure that the Forensic Science Center has the capability to perform DNA analysis at all times. I really don't think that this once a year visit is sufficient to convince me that the center will be operational for the purpose of DNA analysis at all times. Because it's a critical statistic, it's a critical piece of research, and a critical piece of information that will link evidence to criminal activity. And this Forensic Science Center has to be effective and efficient in the administering of the information that is required. And once a year, in my mind, is not convincing that this center will be fully operational. So I ask for consideration for that, and that the custodian will be responsible for ensuring that the Forensic Science Center has the ability to perform its work at all times and not just at a one-time visit per year. Madam President, but as we link this to the roles and responsibilities of the custodian, clauses 4 to 6 refers to the standards to be determined by the custodian. And Senator Mark touched on a very important point with respect to the custodian. It says here in Clause 4 of the regulations before us, Clause 4 states that the custodian shall set the minimum standards for entry onto and removal of data on the DNA data bank. So the custodian can set the standards for entry as well as removal. Then Clause 4.2 says that the custodian can also now, in addition to setting the standards, he or she can enter, he or she can amend, or he or she can delete. So not only is the custodian responsible for the standards, but the custodian is also responsible for entering data actually onto the database. 5.2 is saying that the custodian shall keep an up-to-date log of all data reinstated, suspended, amended, or deleted. So now the custodian who has set the standard is now entering and has the ability to delete or amend. And then 5.2 is saying when he does that, he keeps the log. He or she keeps the log. And then Clause 5.3 says the custodian shall now report to the minister or give an annual report, I should say, or submit an annual report indicating the samples that have been suspended, amended, reinstated, or deleted. So the custodian is the check and balance of the power unto himself because he's establishing the standards by which to do it. Then he's doing it. Then he's saying, okay, then in 5.2, I will keep the log to myself, but I will report unto me of the activities that I have done, and then I will report annually on what I have done. In my mind, there is no segregation of duties and no internal controls that keep the custodian in check in performing his function. Too much autonomy is given to the custodian here with no check and balance. So if the custodian decides that he wants to delete or amend, the custodian is well within his right to do so. If he doesn't update the records, because it's his records that he's keeping, it's okay. And then if he doesn't report on it, the entire thing slides. And so as an audit function or an internal check and balance on the function and role and function of the custodian, I think this needs to be addressed. Too much power is vested in the custodian and it remains unchecked. Madam President, there's also an aspect of that clause which concerns me a little, and it says here in Clause 5 that the custodian can delete or reinstate. The custodian can delete or reinstate. If the custodian is deleting and has the ability to reinstate, then where is the data held during that time? How can something be referred to as having been deleted and then at a later date reinstated? Where is the reservoir? Where is that storage being, or where is that data being held? And what are we really referring to as deletion when we say the custodian has the ability to delete and reinstate? I'm a little bit concerned about that. Part 3 of the bill refers to taking samples. We were told today by the Honorable Attorney General in his address that there are probably some 15,000 swabs or somewhere that will become available for testing. What I'm saying here is that Clause 7 of the bill, Clause 7 of the regulations refers to taking samples, but nowhere in the regulations does it specify how the sample is to be taken. It does not specify the type or the mechanism or the package or the swab that will be used to take the sample. And then how is it that the Attorney General can list here the type of swab that will be introduced, but the regulation does not govern what type had to be purchased? So I'm a little bit confused here, and whether or not the swab or the package that he has proposed was appropriate. All I'm saying is we need to specify in the regulation the type of sample kit that will be used and the content. And I just want to quote from the DNA regulations of Canada, which says, the commissioner, and this is from Canada, the commissioner must approve a DNA data bank sample kit that ensures the integrity of samples of bodily substances transmitted to the commissioner. The kit must include detailed instructions on the procedure for collecting and preserving a sample and how to prevent its contamination. B, a sample collection medium that allows the sample to be safely handled and preserved, and the items necessary to collect the sample. If we are empowering many people to take samples, then the operating procedure to collect the sample should be standardized, the equipment used should be standardized, the procedure and the instructions along with it should be labeled effectively to each package. And I do believe that should be part of the regulations as well. Madam President, in terms of the taking of samples, clauses 7 to 12 also specifies samples being taken from crime scenes, private hospitals, and health facilities. 7 to 12. In each of these clauses, it goes on to say that the sample shall be forwarded. The sample shall be forwarded to the Forensic Science Center. That word forwarded there gives me the impression that once taken, and a third party can get involved in transporting the sample from where it's taken to the Forensic Science Center. That's the impression of forwarded for me. But when you go to the Act that governs the DNA collection, and you go to clause 23(1), it says here, a police officer or qualified person who takes a sample from a person under this Act as soon as practicable shall submit. So in one case, we have the regulation saying forwarded, and the Act is saying submitted. In my mind, the submitted has a personal connotation with it, where one submits a sample that he or she would have collected, whereas the regulation is saying it can be forwarded, and the regulations even provide for storage and transportation. So in my mind, there is some issue there that I think we need to address it to indicate whether or not the word submit in the Parent Act requires the person who collected the sample to submit, or according to the regulation where it says to be forwarded, the sample can be forwarded. In my mind, that needs to be addressed in the regulation if it has to be harmonized with the Parent Act. Madam President, Part 4 of the regulation also pertains to analysis of samples. This analysis of samples can be performed by the Forensic Science Center or an approved laboratory. Clause 13(2), or Clause 13, I should say, says, subject to subregulation 2, where the Forensic Science Center receives a reference sample, the director of the Forensic Science Center shall ensure that the reference sample is analyzed and a DNA profile generated as soon as possible by the Forensic Science Center or an approved laboratory. It also says the same in Clause 13(2) with respect to with respect to crime scene material. Here's my question. Under what conditions would a sample be sent to an approved laboratory and not to the Forensic Science Center? I do not know. How will the laboratory become approved? Who is responsible for transporting the sample from the Forensic Science Center to the approved laboratory? Is the software at the approved laboratory consistent and compatible with the software at Forensic Science Center? And my reason for that is to saying that the reporting requirements, the output of the software has to be almost the same in order for us to have consistency in reporting it. What is in place to ensure that the approved laboratory does not maintain a copy of the profile or maintains confidentiality of the sample and the data generated? Who establishes the paper trail to indicate that the Forensic Science Center has released a package to an approved laboratory? And who is accountable for when the package is returned? All of this concerning an approved laboratory is absent from the regulation. And if clause 13.1 and 13.2 refers to the use of an approved laboratory, then in my mind, we need to establish regulations that govern how the approved laboratory would function. And I think that is missing in the regulation. Madam President, also there may be times that the sample received may not be appropriate or may not be of the form that can receive the proper analysis. And I'm asking in the regulation, is it possible for the regulation to consider where a second sample can be requested, probably based on the fact that the first sample is inadequate, non-compliant, decomposed, or even contaminated? Is there a process whereby a second sample can be referred to or can be requested? Madam President, clause 15 of the regulations pertain to the request for information from the custodian with respect to DNA samples. It outlines in Schedule 1 a form which specifies or which must be filled out in order to access information from the custodian. However, this form fails to address the purpose for which the search is being requested. It does not address whether it is for criminal proceedings, human trafficking, sexual offenses, anything like that. The schedule or the Form 1, which will be used to request information from the custodian, does not indicate the purpose for which the request is being made. And therefore, I ask for that to also be considered with respect to that form. Part 6 of the legislation pertains to records that are being kept or that are required. Clauses 7 to 12 says when samples are collected, it needs to be accompanied by an entry into the DNA record when it pertains to a sample, or an entry into the register of crime scene material where the crime scene material is being sent for analysis. However, Schedule 3 of the regulations give a step-by-step listing of the information that should be submitted to the Forensic Science Center. These include date received, name and date of donor, involvement in the matter, among other things. There are 8 of them. However, at no place in that schedule, Schedule 3, is a copy of the DNA record or a copy of the DNA of the entry onto the crime scene material register is required. And therefore, when a sample is being submitted at the Forensic Science Center, I do believe, as clauses 7 to 12 specify, a copy of the record into the DNA record, a copy of the entry of the DNA record or of the crime scene register also needs to be included in Schedule 3 for submission at the Forensic Science Center. Further, Madam President, with all of this information requirement at the Forensic Science Center, when a sample is to be submitted, then we need to ask the question, what happens when a sample is going to be submitted and there is missing information? The forms are not completely filled out, or a package the seal on the package appears to have been broken or even tampered with. When that person at the Forensic Science Center is receiving that package, if that person is not comfortable with the quality of the package or the information requirement that he or she is not being made available, then what happens to the sample at that point? The regulation does not speak to that. Where an unacceptable package is presented for whatever reason, the Forensic Science Center is unable, and from the regulations, we do not know how a package like that would be handled. Part 7 of the regulation pertains to storage. Storage of the material, and clauses 24.1 and 24.2 outlines where and how the packages are to be stored. It is very specific, even with the parent act, saying that the packages need to be sealed and labeled and need to be held in a designated area, and an officer will be responsible for managing that area. The regulations here does not state what happens when the package that is delivered is not sealed, or when the package having been received that sealed is now leaving after storage and the seal on it is broken. The person who is designated to manage this facility needs to confirm that a sealed package was received, and upon retrieval, a sealed package was delivered. That way, the integrity of the sample or the package is maintained, and that too is absent with respect to storage. Section 8 of the regulations pertain to transportation, and very specific care was given to ensure that the transportation of the sample is done in a way to ensure the integrity of the sample and the sample is not damaged. However, we all know that during transportation, many things can occur. What happens to a package when it becomes damaged during transportation? The regulation here is also absent on how to treat with that. Part 9 of the regulations pertains to privacy standards, security, and access. Part 9 of the regulations here, which deals with Clause 26, Clauses 27, and Clause 28, pertains to privacy and access to the data bank and disclosure of DNA data. I raised this point earlier that with respect to an approved laboratory, what is in place to prevent an approved laboratory from sharing information with unauthorized sources? I raised that before. However, Clause 28 also allows a country who wishes to access the DNA data to be able to request this assistance through the Central Authority in Trinidad and Tobago, and they shall do so in writing. I am asking, given that we are now sharing this information on an international sphere or globally, are there any arrangements in place to ensure that when the country receiving the assistance from Trinidad and Tobago is obligated to provide confidentiality of the data provided? Because once it gets out of the hands of Trinidad and Tobago, we have no control over it, and therefore a privacy element or confidentiality element with respect to international partners also need to be considered. Madam President, my intent here today is not to be long, but to say that while I do commend the last administration for the work done in tabling the DNA legislation, I really want to commend the efforts of this administration in bringing the regulations to this House in such a short time since they've been here to operationalize this act. However, Madam President, in going through the regulations, I have found some element of gaps that I'm seeking to have addressed in an appropriate way, and I trust that the government would be receptive to the suggestions. So with that in mind, Madam President, to just wrap up and to conclude my presentation today, I did ask for some bit of consideration to ensure that for the custodian to be able to ensure that the Forensic Science Center is able to perform its work at all times and not just limited to at least once a year. I have raised the issue of the powers of the custodian. With the powers given to the custodian makes the custodian accountable unto himself or herself. Segregation of duties and internal controls to ensure that the role and function of the custodian is not performed in any ill manner, and as a check and balance for the integrity of the information need to be considered in strengthening its role and function of the custodian. The sample kit referred to by the Honorable Attorney General also needs to form part of the regulation to define what the sample kit entails, the procedures for taking a sample, and the procedures for storing. Reason being, not all persons will have full information at the time they are required to take the sample. So the information with the sample kit should also be part of the regulations. I did have some element of confusion in my mind with the samples either having to be forwarded to the Forensic Science Center or according to the act submitted. I do ask for some element of clarity with respect to that. In addition, when the data is being submitted to the Forensic Science Center, Schedule 3 does not allow or does not permit a copy of the entry into the DNA record or a copy of the entry into the crime scene register to be submitted with it. I'm asking that Schedule 3 be amended to include this. The regulations in no way addresses how to treat with samples when they are being submitted and they are incomplete records or damaged sample packages. Part 7, I think, or Part 8, which deals with storage of samples, does not ensure that samples received are sealed and the person who's retrieving the sample is retrieving a sealed package. It just needs to be strengthened there. Under what conditions could a second sample be requested? And the purpose of the search should be included in Form 1. Defective packages due to transportation also needs to be addressed. And lastly, very importantly, I think the area of using the approved laboratory is remains very much unaddressed. There's several issues with respect to approved laboratories in terms of how it obtains approval, the software requirement, the privacy element, the sharing of information. And so, Madam President, with respect to approved laboratories, I don't think a piecemeal fix to the regulations can help, but an entire section designated to the role to approved laboratories addressing all of the concerns would be really welcomed in strengthening the legislation. And with respect to international cooperation, I did ask that some element of agreement with international bodies be established, that the privacy and confidentiality of the information obtained be kept confidential between the agencies or among the agencies. So with that, Madam President, while I thank you for your time, I do commend the government for bringing these regulations. I trust that they will receive my recommendations in good light, and I trust that this really helps Trinidad and Tobago in the delivery of more effective justice to our citizenry. Thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President, for the opportunity to join this debate. Madam President, we are here on account of Section 34 of the Administration of Justice DNA Act, Act number 5 of 2012. And Section 34 of that Act, Madam President, provides for the Minister to make regulations for the purpose of giving effect to this Act, and provides that regulations made under this subsection are subject to the affirmative resolution of Parliament. Madam President, let me make a few things clear. The first is, I followed the proclamation of the anti-gang legislation recently, and I congratulate the Attorney General, the Parliament, and the country for putting that legislation in place. It is vital legislation. But not too long after it was proclaimed, I saw a report attributed to the Commissioner of Police. The Commissioner of Police was saying, legislation is no magic wand. And it is consistent with what I say about every piece of legislation that comes to us. Sometimes a bill comes to us and we create the act and we leave the regulations unattended. Sometimes we create the bill and the regulations come before us and they approve, but the administrative, technical, financial, human resource, all those matters are left unattended. And our very good work fails. We have before us a rare opportunity to get everything together as it relates to the use of DNA evidence in the criminal justice system in Trinidad and Tobago. It's a rare opportunity for us as legislators, and it is one that we should embrace today. Madam President, this piece of legislation or these regulations don't work on its own. We have as a Senate worked on several pieces of criminal law legislation already, and we have those that are still to come based on the legislative agenda. Madam President, these regulations and the act giving rise to the regulations will work in tandem with plea bargaining, for example. The disclosure of evidence rooted in DNA may lead to a plea bargain, and we have had the opportunity to set in train in this country plea bargaining legislation. This, if it's the sort of evidence that's disclosed, may lead to a decision on the form of trial. Because in this Senate, we've had the opportunity to participate in a debate on judge-only trials. And it may give evidence that is available, may give rise to a decision, an election on the type of trial. This may work in tandem with electronic monitoring. Of course, that is the classic example of a piece of legislation that has been passed but suffers on account of the administrative and other arrangements not being in place. This, Madam President, will work in tandem with bail legislation, and we've worked on bail legislation in this House. We've worked to, for once, give something for criminal accused looking to access bail to work with, and we made some changes in relation to the access to bail. This will work with the current piece of legislation being considered in the other place relating to the establishment of a court with criminal jurisdiction, a specialized court with criminal jurisdiction. This may work with pre-trial procedure, which has been in and out of Parliament in various forms, but I'm speaking about legislation that aims to eliminate or address the issues relating to indictable offenses and the proceedings relating to those offenses. This will work with anti-gang, and it will work with anti-terrorism. So this is not a simple piece of work we are doing here today. We are advancing the cause of the criminal justice system. We are trying finally to introduce a piece of technology that has existed and has been used in other jurisdictions which we wish to emulate. And it's in our hands today, and I hope that we do the right thing. So Section 34 brings us here. Madam President, let's look at the history. As the Attorney General has said, almost 20 years ago, we embarked on this road. Almost 20 years ago, 1999. And 1999 is a very interesting year. It's the last time, Madam President, that the murder figure has been under 100 murders a year, 1999. And I'm not saying that DNA is used exclusively in murder trials. It's used in trials across the board. But 1999, we were at 93. And in very few years thereafter, we went down. The most significant year in which we went down was the year of the infamous state of emergency. In very few years we went down. And in 1999, we introduced the DNA Identification Act 2000. And that piece of legislation addressed the basic elements of DNA legislation. Of course, in retrospect, we would see that it was deficient. But in the year 1999 and in 2000, when it was passed, it represented, I suppose, the best that the legislators could do at the time. It addressed the issue of taking the samples. It addressed the issue of a court order leading to the taking of the samples. It addressed the process, and towards the end I will talk about the process, and perhaps one of the most vital part of DNA legislation is the chain of custody in relation to the samples. And the other parts in terms of the establishment of the DNA board and the labs and the work of the forensic analysis and so on. And that was the 2000 Act. But it was never proclaimed. It sat there and it was never proclaimed. And 8 years would pass before, as a parliament, we get back on track with DNA legislation. But what happened from 1999 to 2007 when we got back on track? Well, this country experienced 2,000 murders. On the one hand, we understand that we have a role in suppressing criminal activity, discouraging criminal activity. Some people believe that hanging is a disincentive. We could argue over that. But we were dealing with 2,000 murders from 1999 to 2007. That period when we had DNA legislation, we had a piece of legislation and we did nothing. So that on the one hand, you have suppression in relation of the crime, but on the other hand, you also have the criminal justice system. And think about whether this may have been a catalyst in dealing with criminal cases at the time, and it may have, I don't know the extent to which, we could only reflect on it. And in 2007, we got back on the ball. And out of that came Act number 24 of 2007. And that, Madam President, in a similar way, built on what was in place in 2000 and not proclaimed. So again, Act number 24 of 2007, the DNA Act, dealt with taking the samples, introduced the concept of the protective services on persons who may be at a crime scene or may be expected to be at a crime scene, volunteering their samples. It dealt with what was called post-collection procedures, addressing the issue of chain of custody. It dealt with the lab that we've discussed here, and everybody would talk about the pros and cons of the Forensic Science Center as the lab. It dealt with the issue of the DNA board and the data banks and so on. So this expanded on what was in place in 2000 and what was not proclaimed. And the Act number 24 of 2007, as the Attorney General pointed out, repealed the 2000 legislation, which was never proclaimed. And Madam President, from 2007 to 2011, nothing was done in relation to DNA, including implementing that act. Nothing was done. And between 2007 and 2011, 4 years, there were another 2,000 murders. And again, on the one hand, you would say that law enforcement should have been engaged, and we as a society should have been engaged in suppressing, disincentivizing, discouraging the murders. But you have to ask yourself, if the prosecution, if the investigation, the judiciary had it at its disposal, something which has clearly assisted criminal justice systems around the world, those numbers may have been different. So from 2000, Madam President, 1999 The last year we were under 100 murders a year. From 1999 to 2011, 4,000 murders. And I'm not even going into the other categories of crime. And then in 2011, we embarked on the piece of legislation that gives rise to the motion that's before us today. And that is the Administration of Justice DNA Act. And I listened to my friend, Senator Mark, my very good friend. I make two comments on his contribution. First is to say, I think the word is gall, Madam President. I don't know if it's, I hope it's parliamentary, but it's a proper English word. No, I think it's gall. My friend had the gall to say, ask, what were you doing? What was the executive doing from 2016 to 2018 in bringing these regulations? Well, we were busy fixing everything you left undone and halfway done. That's what we were doing. Because in the same breath, when that part of your brain reaches to formulate the question, what were you doing from 2016 to 18, it should have triggered a question in your own mind, what was I doing from 2011 to 2015? To me, that is how it should have worked. And I plead corrective action. What were you doing, Senator Mark? This was a piece of legislation. On one occasion before that, you did not get the support of the PNM in opposition. But on this occasion, you had whatever the deficiency of the act. You got the required support, and you sat there doing, with all the resources, doing nothing. Not little and not, nothing. What we were doing from 2016 to 2018 is working on the recruitment, the administrative part, working on setting up the physical infrastructure, working on eventually recruiting a custodian, and working on the regulations that is before us today. That is what we were doing. And you know, Senator Mark, I really don't like to bring back bad memories for you. But sometimes you force my hand. And I'm listening to you on this custodian, still unknown and unidentified, well, at least to me, questioning the independence, the trust, the training, the integrity. And again, no, you may ask that, Excellency, become the custodian. Again, when you reached to formulate, okay, when you were formulating the issue of training, of the custodian and the trust and independence and we rely on and so on, I wondered if you considered Rishmi. I know it hurts you.
They wish
I
it would
know.
go away. They wish we would
And
go away.
I did say in the spirit of goodwill, I did not wish to spoil your afternoon. But the legislation that created the Strategic Services Agency created an apparatus dealing with Trinidad and Tobago's counter-narcotic strategy. It wasn't a small thing. It's a big thing. Recognizing Trinidad and Tobago's role in the transnational movement of narcotics from one part of the world to another part of the world. And it wasn't a simple matter. And the head of the SSA was meant to be a highly qualified, highly connected person who would advise not only the country, but would play a pivotal role in the world of counter-narcotic strategy, recognizing that the movement of narcotics touched several jurisdictions. And I am not questioning the choice, but Rashmi Ramnarayan at best was qualified in IT, a basic degree in IT with zero experience, expertise. Nobody in the world of counter-narcotic strategy knew Rashmi Ramnarayan. No, it's very difficult. It's very difficult to understand.
Minister, I understand that you are making a point to answer a point that Senator Mark raised. But having made the point, I would ask you to move on now.
Thank you very much, Madam President. As I said, I expected that it would be a hurtful discussion. So, Madam President, having established that, this DNA regulation, which stems from the DNA Act, is never going to be a very simple matter. It is one of those areas in which science and technology, science and law interact, one being exact but not foolproof, and that is not law, and one being continuously adapting to new trends and new technologies and new social situations. And dealing with DNA technology and dealing with the use of technology, we also enter onto very dangerous ground. Because what the Act and what the regulations recognize is that we are dealing with, first, an interference with fundamental rights. Secondly, as part of that interference, an interference with privacy rights. We are dealing with risk, and every speaker on these regulations will talk about risk in relation to collection, handling, chain of custody, preservation, integrity, trust, reliability. Every speaker will address those issues, so that there will always be concerns and there will always be a temptation to be highly prescriptive in protection, or at least in striking the balance. There'll always be, and I listened to Senator Shrikissoon, who's pointed out his concerns as he's entitled to, there'll always be the temptation to be highly prescriptive, to cover every single possibility, and, Madam President, to run the risk of another 19 years passing. In our view, the regulations that are before us target what we considered to be the key issues flowing from the Act. And I have to say, Madam President, that we have to be careful. Before us, and that is why I started off with the reference to Section 34 of the Act, before us is not a bill to amend the Act. We are not trying to change the Act or to fix deficiencies in the Act. In reality, Madam President, the AG has said, we are expanding on what is set out in the Act. And the AG identified 8 areas and cross-reference those areas to the Act itself. And what we have before us are regulations which aim to develop on matters set out in the Act. And we have to be careful that we do not attempt to prescribe or be prescriptive about every human emotion, every practical situation foreseeable, and in doing that, we spend another 19 years. And the Attorney General, Madam President, has identified the 8 sections of the regulations. And I would identify of the 8, the ones that I believe requires our close attention. The first thing I would point to is the issue of the custodian. And I want to correct something Senator Mark said. It says in relation to the custodian that there is, the section does not address laboratories other than the Forensic Science Center. I accept what he says in relation to the once-a-year visit to the Forensic Science Center. But Regulation 3, Sub 3, says specifically that the custodian may, subject to the regulations and standards made hereunder, accept profiles and documentation generated from the Forensic Science Center or an approved laboratory. So it addresses the role of the custodian in relation to not only the Forensic Science Center, but the approved laboratories, which is defined in the Parent Act. The second area I want to draw your attention to is a part of the regulations dealing with what I call process. And that is a part that begins at regulation number 7 and ends at 12. And that is, to me, one of the most important parts of any piece of statutory instrument dealing with DNA. Because the collection first at the site, the management of the samples taken, the transfer of custody from hand to hand. We talk about transport. Senator Shrikissoon referred to the use of the word forward. All of those things, not new to criminal law jurisdiction, not new to jurisdiction, in relation to any prosecution. This matter of collection, recording, identification, chain of custody, preservation, presentation are vital factors of any criminal prosecution. So that the process is something that we are trying to write to cover as many of the practical situations as may arise. But we have to allow for interpretation, extension, applications to situations that we may not have directly provided for. And we have to be careful that we do not try to write regulations to cover those things which may not arise, may not be foreseeable, may arise in the future. We have to deal with what is before us. And to me, the process set out in Regulation 7 to 12 adequately cover what we are likely to encounter in dealing with DNA collection, sample collection, and custody, transport, and forwarding, and all those matters. Madam President, Regulation 16 in Part 6 deals with the vital issue of record keeping. Regulation 16 onwards deals with record keeping, 16 to 23. And again, as the Attorney General has pointed out, this is important. This is important for... Thank you.
Honourable Senators, we will suspend at this stage and return at 5 p.m. So the sitting is suspended until 5 p.m.